Actavis, Eli Lilly and Company, and Actavis UK Limited and others.
Before we start, I should record the fact that the court is ordering that certain pages and paragraphs in the papers before the court should remain strictly confidential. If anyone is uncertain about this or anyone wishes to refer to anything in those pages or in the papers generally, copies of the order will be available. But as a result of this, if anyone does reveal the contents of the pages identified in the order, they will be committing a contempt of court. Thank you. Mr. Mitchison.
My Lords, I appear with my learned friends Mr. Waugh and Dr. Barron for Eli Lilly, and my learned friends Mr. Alexander, Mr. Raphael and Ms. Jamal appear for Actavis.
Yes.
I hope your Lordships have seen the agreed timetable sent through last week.
Yes, thank you. I'm glad it's finally agreed.
Yes, indeed. Although both parties have appeals to this court, subject to your Lordships, it's agreed that Lilly should go first.
Fine.
And I propose to address you today on Lilly's appeal, that is the question of the scope of claims, equivalence and direct infringement. My learned friends will then respond to this and address you on their appeal on indirect infringement and prosecution history. And Mr. Alexander and I are agreed that I can leave the issue of prosecution history until I reply to my learned friend's appeal on that issue. And with your Lordship's leave, Mr. Waugh will deal with a separate topic of secondary infringement in response to Actavis's appeal.
Thank you.
My Lords, in case it helps to see the overall structure of Lilly's appeal, what I propose to do is as follows. Start with a brief overview of Lilly's case, then describe Lilly's invention, the patent, and Actavis's products. Thirdly, touch upon Swiss claims. Fourthly, look at the legislation, including the reason that equivalents are relevant at all. Fifthly, look at the approach in other EPC contracting states. Sixthly, look at the approach in the UK hitherto. And then seventhly, look at the judgment of the Court of Appeal and why we say the Court of Appeal was wrong. And then finally, my Lords, I will very briefly touch on the foreign patents, which follow on from our submissions in relation to the UK, save for one short additional point arising in respect of the application of French law. There is no challenge to the judges' findings of foreign law as set out in the judgment.
Can you, just out of interest, tell me why the market for these products in countries of similar size is significantly higher outside this country?
Well, that's a good question. I don't know the answer off the top of my head, and I will find out. And
There's nothing to do with the case, so there's no reason why you should know, but it is a matter of passing interest. Thank you.
Indeed. My Lords, our overview. As your Lordships will appreciate, Lilly's appeal is concerned with clarifying the precise circumstances under which something which is a variant to the literal wording of a patent claim should be held to be within its scope. And we feel it's important to explain what Lilly's case is and is not at the outset, as much of Actavis's written case we submit is directed at the wrong target. The Court of Appeal found against Lilly on so-called improver question 2 and 3.
Yes.
That is to say, the questions of whether it was obvious that the Actavis variants have no material effect on the way the invention in the patent worked, and whether there was any reason why the variants would be understood to be excluded from the scope of the claim.
Those two questions are to be judged as at the priority date, are they?
Well, that's the position in the UK so far,
Right.
my Lord, and I don't think I need to go beyond that today, but we do note that in the Netherlands, for instance, they are allowed to take into consideration the common general knowledge as at the date of the infringement. So the approach does vary across the EPC.
Is that the position in Germany as well?
In Germany, they look at the priority date, my Lord. So
They look at priority date.
Only priority date,
Sorry.
yes. So on question 2, Lilly's appeal focuses on what information the skilled person is deemed to have available when assessing whether the variant has a material effect on the invention. And we submit that the current law in the United Kingdom clearly favours Lilly on that issue, other than as applied in the Court of Appeal. On question 3, improver, Lilly has 2 points. It asks, first of all, whether the ultimate question of the scope of the claims, including equivalence, can be answered satisfactorily by posing a single question of the construction of the words of the claim, or whether a two-stage approach is more convenient, as is carried out elsewhere in the EPC.
If it is a one-stage approach, you're in obvious difficulties.
Well, my Lord, it depends how one interprets Amgen. We say it is possible to do it in a one-stage approach and take equivalence properly into account, but the courts below certainly didn't do that. But it is more difficult to do, as I shall submit, a bit like trying to imply terms into a contract. We submit it's easier, as your lordships have found, to do that in a two-stage test, and we submit the same for equivalence.
Understood. Thank you.
And connected with this, we also seek to ask whether the effect of the new Article 2 to the Protocol on Interpretation of Article 69 is to require a less literal approach than the courts below have adapted on the facts of the present case. Contrary to Actavis's suggestions, neither of Lilly's submissions require this court to depart from the previous English approach, and much of what Lilly submits is entirely consistent with Catnick and Improver and Amgen when read as a whole. And it's only if certain parts of Amgen are taken in isolation, particularly on the ultimate Improver question 3 issue, as the courts below did, that any refinement is required. So all Lilly is asking from this court is to clarify and, if necessary, update the existing guidance in the light of the EPC 2000, and to do so in a way which is in keeping with the continental jurisdiction's approach to applying the EPC. Further, as far as your lordship should be aware that as far as Lilly is concerned, the issue of real commercial importance on this appeal is direct infringement. As your lordships will have gathered, activists have come up with a way which, according to the first instance judge at least, provides activists with a workaround to the Court of Appeal's finding of direct infringement, and that is the use of dextrose instead of saline to make up their products. So as things stand, Lilly needs to win on the issue of direct infringement in this court to provide it with the commercial value which it submits that its invention merits. And with that summary, I will turn to the characterisation of Lilly's invention. And my lords, just to help you, this is addressed at paragraphs 13 to 19 of our written case.
Paragraphs?
13 to 19, my lord. So, my lords, the earliest priority date of Lilly's patent is the 30th of June 2000, and at that date, pemetrexed was already known as a type of drug called an antifolate.
Yep.
And this group of drugs interferes with key molecular pathways requiring folate, which are necessary for cell division and DNA synthesis.
Yep.
And as a consequence, the administration of antifolates was known to stop rapidly dividing cells, such as found in tumours. Now, unfortunately, the successful use of antifolates to treat cancer had been limited, in spite of them being around for many years, because of their toxic side effects. They were effective at killing tumour cells, but they caused so much collateral damage that they were very difficult to tolerate, and in many cases couldn't be used at all. Indeed, at the priority date, although pemetrexed had been shown to be effective against multiple cancer types in early stage trials, its progress to becoming an authorized drug was in severe doubt because of its toxicity. And in critical large-scale clinical trials, people were dying because of the pemetrexed and not because of the cancer. So it was at that point that Lilly's scientists discovered that the toxicity of pemetrexed was correlated with levels of something called methylmalonic acid, and that reducing levels of methylmalonic acid by administering vitamin B12 reduced toxicity. Moreover, they discovered that if patients were given vitamin B12 together with pemetrexed, not only were the toxic effects of the pemetrexed alleviated, but this benefit was achieved without loss in efficacy of the pemetrexed against the tumour cells. As a result of Lilly's invention, pemetrexed is now in use across the world to treat a wide variety of cancers, and its use is always accompanied by vitamin B12. And without Lilly's invention of combining vitamin B12 with the known active ingredient pemetrexed, pemetrexed would not have become a viable treatment for cancer.
Right.
And we can see all of this reflected in the patent, which I'd like to take you to, if I may.
Yes.
It's in Appendix Part 2, Tab 1, E-bundle number 737. And your lordships will see on the first page, 737, combination containing an antifolate and a methylmalonic acid lowering agent as the title. And then if your lordships turn to paragraph 1, you'll see explained that life-threatening toxicity...
What page is your paragraph 1 on?
734. Top left.
734, and is it more convenient if I
No,
refer
it's
to...
fine.
You were using 737, that's all.
737 is the electronic bundle number, I'm sorry, my lord.
Brilliant.
734 in the written. I'm afraid we're going to have to pay this.
734.
I think we're all tending to work from paper.
I'm grateful, that will save confusion.
Sorry.
I apologise.
If you spool forward 10 years, we'll probably all be working, those of us that are here, if any of us will be working from electronic, but at the moment we are paper. Yep.
I'm grateful. So it's page 734, paragraph 1, and that explains that life-threatening toxicity remains a major limitation to the optimal administration of antifolate. So it sets out the problem that the patent is going to address. Paragraph 2 introduces antifolates and explains that they represent one of the most thoroughly studied classes of anti-neoplastic agents, and it gives some examples. And then at line 15, it explains how they work, and explains that they inhibit one or several key folate-requiring enzymes of the various pathways in the cells.
Yep.
And then at line 26, it introduces a couple of antifolates, including pemetrexed disodium, Alimta, Eli Lilly and Company, etc., explains how they work.
Yep.
Paragraph 3 explains the problem. A limitation to the development of these drugs is that cytotoxic activity and subsequent effectiveness of antifolates may be associated with substantial toxicity for some patients, and goes on to explain that some clinical trials have had to be abandoned because of the toxicities. And then paragraph 5 is the key paragraph in describing what the invention is, and perhaps your lordships would just read that to yourselves.
Yep.
And I should also point out paragraph 6, which introduces folic acid together with B12 and the additional discovery that when administered together, there's a synergistic benefit. And in fact, in use, both of them are used together with pemetrexed.
Yep.
Further, the invention is described at paragraph 16. Perhaps your lordships will just look at that.
Yep.
And then over the page, there are various definitions given, and over the page at paragraph 22, the terms antifolate and antifolate drug are defined, said generally to refer to a chemical compound which inhibits at least one key folate-requiring enzyme of the thymidine or purine biosynthetic pathways, etc. And it then goes on to say the antifolate or antifolate drug for use in this invention is pemetrexed disodium Alimta, as manufactured by Eli Lilly and Co.
Yep.
Now, it wasn't in dispute that the oncologists to whom this patent was addressed knew perfectly well that the pemetrexed ion was doing the good and the bad, causing the toxicity, and in combination with the B12, that toxicity was alleviated. That was the important part of the antifolate, and it's recorded at the Statement of Facts, paragraph 5. My lords, the patent then goes on to introduce experiments on mice on page 5, and we can see the results of those experiments in paragraphs 42 and 43, where the inventors describe how the level of vitamin B12 resulted in excellent tumour activity at low doses with little or no toxic effects. And then they move on at paragraph 44 onwards to deal with the trials on humans and the introduction of B12 and folic acid is mentioned in paragraphs 45 and 47. The folic acid can be taken orally, like a multivitamin. The vitamin B12 needs to be injected. And you'll see in paragraph 44 At that stage, the cycle involved 2 weeks on for pemetrexed and 2 weeks off. It's now given every 3 weeks, and the folic acid and the B12 were administered in advance of that. It's not in dispute that pemetrexed and antifolates generally have to be injected, and that was part of the common general knowledge, and that's described in the specification as well. And then the results are given in the following page in paragraph 55 and 56 in table 1, and you can see the quite startling results. The 55 explains that 4% in clinical trials, 4% there was drug-related death without the B12 and 50% grade 3 to 4 neutropenia. And then when the B12 and the folic acid are given together, the reduction in deaths, this is line 29, goes to less than 1% in the 480 people treated in the clinical trial, and also a considerable reduction in drug-related grade 3 to 4 toxic events. And you can see that set out in table 1. So that shows the really quite remarkable benefits of giving B12 and folic acid with the pemetrexed. My lords, the claims are then set out. I think it's only necessary to look at claim 1 for the purposes of this appeal. And we'll come back to this to look at the derivation of Swiss claims, but it is in Swiss claim form, so it's in the form use of pemetrexed disodium in the manufacture of a medicament. That's the Swiss claim form. And then it goes on to say, for use in combination therapy for inhibiting tumour growth in mammals wherein said medicament is to be administered in combination with vitamin B12.
Yep.
So a number of points to note from here, my lords. Firstly, it has to be a medicament. It has to be suitable to give intravenous administration, as we've said.
Yes.
It's not about the use of pemetrexed as an antifolate. That's clear from the specification of the patent. That was already known. But instead, it's about a combination of pemetrexed with vitamin B12 to make the pemetrexed tolerable yet still effective. Nor is the invention concerned with identifying a new counter-ion for pemetrexed. And so, in our submission, the sodium counter-ion referred to would not be seen as an essential part of the invention. Finally, there's nothing else in the patent to indicate that the reference to the disodium salt, which was the only form of pemetrexed that was authorized to be put into people for clinical trials at the priority date, was intended to exclude other sources of pemetrexed as equivalents. Also, my lords, you'll note that the patent doesn't tell you anything about how to manufacture pemetrexed, because it's not about that.
No, it wouldn't.
It's about the combination of pemetrexed and vitamin B12.
Yep, so be it.
So, my lord, that's the patent. And now, if I can just tell you a little bit about Actavis's products. It's not in dispute that Actavis's products work in exactly the same way as the combination of pemetrexed, disodium, and vitamin B12.
Quite.
And as explained at paragraph 5 of the agreed statement of facts, once in solution, as they must be for administration, the cations and anions dissociate,
Yep.
and the anti-neoplastic effect comes solely from the pemetrexed anions. Actavis also admitted that it was known that the sodium ion did not have any appreciable effect on the toxicity of pemetrexed disodium at the priority date. We've got the reference in the bundle if your lordships need that. Consistent with this, the evidence of the oncologist experts in the case was that they refer to pemetrexed disodium today as pemetrexed, just as doctors commonly refer to penicillin as penicillin and not as penicillin dipotassium or whatever particular salt it may be. It's right that the chemist experts who gave evidence were more concerned with the identity of the cation. But crucially, for Lilly's purposes, even the chemists had a reasonable expectation that they would be able to identify alternative salts to the sodium ion to meet the requirements. And this is recorded in the Court of Appeals judgment, and it's probably important enough for me to take you to now.
Yep.
It's core volume 2 at tab C.
Yep.
and it's paragraph 65 on page MS 425. And it's the first full sentence on paragraph on that page. Although the chemist would be reasonably confident that he would come up with a substitute for the sodium counterion, predicting in advance whether any particular counterion would work was not possible.
Yep.
But together with that, my lords, if you could also just look at paragraph 37.1, which is reference to the common general knowledge of the chemist on page MS 416.
416.
416. And your lordships will see at the end of 37.1, Justice Floyd recorded the finding of the judge that salt screening is routine. It's a routine but important part of the process of determining the most suitable form of a drug for formulation. And also, while we've got it open, paragraph 35.2 just records what I've told you about the antifolate pemetrexed being administered intravenously. So, my lords, we'll come back to this, but we say these are important findings of common general knowledge and the expectation, the relevant expectation of the chemist, which we say leads to a positive, should lead to a positive answer on question 2 if the right test is applied. Also, my lords,
could you patent pemetrexed bisodium or any substitute fulfilling the same function which may be discovered in future?
undoubtedly, you could try to use general wording, my lord. Yes, you could have used wording such as...
Supposing they said, we can't identify which, but this is fundamentally what matters is the pemetrexed. We patent the pemetrexed bisodium or any other pemetrexed combination which may be found to work in the future and without having any material, making any material difference to the inventiveness of what we've discovered.
My lord, that no doubt could have been done because there was no text representing that wording in the specification of the patent. Then Lilly, once they'd filed their application, they couldn't amend their claims to write a claim like that.
But you say, do you not, that the effect of the equivalence principle is that they have achieved that?
My lord, on the facts of this case, yes, we say another pharmaceutically acceptable salt to pemetrexed disodium is an equivalent.
Effectively, you've done it. You didn't need to spell it out.
No, that the effect of Article 2 is that the skilled person knows that equivalents are to be taken into account, and this is an obvious immaterial equivalent. So,
and just to cure my ignorance, there's no inventiveness in discovering an equivalent to pemetrexed bisodium, as Actavis have done.
No, that's what I was trying to allude to with the references to the judgment. So the chemist would have an expectation that he could find an alternative. He couldn't say in advance, I know that this one is going to be soluble, but he could carry out a routine test.
And that's why it's not inventive, because it would just be routine.
Indeed, my lord, yes. And I'll take you a little bit later.
That is an important issue between the parties, isn't it? Because the part of the case against you is that because you couldn't say at the priority date that any particular combination would be soluble, and because some further research would be required to identify one that was, there might actually be none, that is the inventive step involved in what activists have done. I mean, that's part of the argument against you, is it not?
It is. I'm not sure even activists suggest that what they have done is inventive.
No.
We certainly don't characterise it that. We say that, as the judge set out, the chemists had an expectation they would find an alternative, and the tests to do so were routine. And if this were an obviousness case, it would be absolutely clear that these are obvious alternatives, and there's no problem finding them.
They're obvious because it is obvious that something would work, even if you don't quite know what.
Yes, and we point
It's
to
a matter
various
of ordinary technical
routine trials, yes, routine. I mean, there's something in the evidence suggests it would take 24 hours at most to carry out the solubility tests to find out which ones work and which don't.
Go through a series of metals and work out whether they're soluble.
Yes, and you store them for 24 hours and then you look for the particulates. These are all standard tests.
There must be a bit more to it than that, mustn't there? Otherwise you would presumably have done it and included all these other chemicals in your application.
Well, that's really the dispute we're having, my lord. Should you have to do that? If there is a doctrine of equivalence and equivalents are deemed to be part of the scope, then you shouldn't have to do that. You can write a clear claim which refers to perhaps your preferred embodiment, knowing that equivalents are covered. The alternative, which is Actavis's case, is you should have to write much woollier, imprecise wording into your claim to try and cover things which you have either thought about and think that someone else might come up with, or you haven't thought about.
Does the argument that you've been outlining require one to revise any of the judge's findings?
No. We say the judge applied the wrong test under question 2. We're perfectly happy with his findings of fact. As we say, it would be absolutely standard that these alternatives are obvious alternatives were this an obviousness case. And in fact, the judge himself refers to solubility tests being routine when he refers to common general knowledge from another case, but it's a good example. I'll take you to that a bit later. And the other point I should make, my lords, it wasn't in dispute that all of the cations used by Actavis for their proposed products would be on the radar of the relevant skilled person at the priority date. We had various textbooks and papers that had a list of suitable cations in it, and all of the cations that Actavis...
None of this is specified in the patent itself. It's all
correct.
Implicit in it. Everybody except me knows that sort of thing.
We would say that it was, yes, part of the routine. It's the skilled person, the relevant skilled person being the chemist and the oncologist.
It's a stretch to say it's in the wording of the patent.
My lord, yes, we don't say that the patent is literally infringed. We say that the wording means pemetrexed disodium. The question is pemetrexed dipotassium an immaterial variant of that, and therefore covered under Article 69 properly?
And is that the principle of equivalence?
Yes, my lord, it is, yes.
But there's no hint of equivalence in the text of the patent?
No, I mean, there's a doctrine which is applied in Germany and the Netherlands, and we'll see where it's derived from, which says that if you disclose other alternatives in your specification and then don't claim them, then you should be deemed to have rejected them as part of the claim. And one can understand that principle of construction. And that doesn't apply in this case because there is no disclosure of alternatives in the specification. And we say if this is a good principle of construction, you should disclaim or reject items or elements that are in the specification but not claimed, then if you also reject the ones that are not in the specification and not claimed, then the doctrine of equivalence has disappeared entirely. So we say it really is directed towards things that the patentee didn't think of or didn't mention in the specification, and that's why this case is a prime example of where the doctrine of equivalence should be applied. Now, my lords, Actavis seek declarations of non-infringement in respect of 3 different forms of pemetrexed. That is to say, pemetrexed dipotassium, ditromethamine, and diacid. And although they don't distinguish between them for the purposes of this appeal, I think it is helpful to see the ingredients which make up these products. Now, this is part of Actavis's confidential information. I'm not going to read anything out, but I'd just like to show your lordships the letter where they set this out. And it is in the core volume 2 at tab J. And it's page 500, MS 573.
So we probably will be sensible to write confidential at the top of the page to remind us.
Indeed, my lords.
Okay, thank you.
And my lords, you'll see there are certain bits of this that are confidential and certain that aren't. So it's not confidential that...
Well, you can read out, you can tell us as we go through, yep.
My lords, yes. certainly, if your lordships would just look at the pemetrexed diacid form,
Yep.
which is under number 2 there, and you'll see in the second line of the table, you'll see the cation that is present in the pemetrexed diacid form.
Yes.
And then if your lordship looks down and sees the pemetrexed ditromethamine form, again, you'll see the second line down, the cation that's present.
Yes.
And so you'll see, and you can compare the amounts of cation, and you'll see that one has more than the other. And then if your lordships would just read the paragraph underneath the table, which gives some explanation.
Beginning with the words we refer.
My lords, yes.
So be it. Yep.
So you can see that although they have different names in this case, in fact the same cation is present in both the diacid and the ditromethamine. And in fact, the UK regulatory authority, the MHRA, refer to what Actavis call the diacid product as ditromethamine because of its other ingredient, the cation. Now,
How many pages off are we here? I'm just looking at the letter which you
We're on
wrote.
576.
I think it's 3 in the core bundle.
576, it's page.
I see. So this is
It's almost always 3.
three. Okay.
Unfortunately, it's not always 3, but it is for the core. I think.
4. It was 4 somewhere else, yeah. It keeps us on our toes.
Yeah.
So
Not just you,
all
Mark.
right. So we must deduct 3 from this letter. Yeah.
No, add 3. 576 on the bu- It's 573 on.
No, we must deduct 3 in order to get to the hard copy.
Yes.
Yeah.
Sorry.
Now, my lords, the most relevant product is the first formulation I asked you to look at, on the basis that this is the product which Actavis has subsequently launched. And we showed a depiction of that at paragraph 29
Yes, you did.
of our written case.
Yep.
And you can see from the product itself, it's called pemetrexed. It's clearly soluble in a liquid, as the judge acknowledged.
Yep.
Sorry, which page in your written
Page
case?
It's
221.
paragraph 29, it's page 8
Page
of our,
8 of that,
which is,
yeah.
I think, hard copy 221
Yeah.
in tab 10 of the core bundle.
Paragraph 29.
Paragraph 29, yes, my lord.
Page 224 of the.
224 of the electronic.
Yep. Yes?
Now, Actavis admitted that their products were to be authorised as a generic medicinal product
Yep.
based on Lilly's Ellipta, and that on this basis, the products would dissociate into their constituent ions in solution, and that this was obvious to the skilled addressee. And can I just show you the admission on that? It's at core volume bundle 2, tab M,
Thank you.
and it's paragraph 78 of the reply. It's hard copy page NS 647,
Yep.
page 650 in the electronic bundle.
Yep, thank you.
And perhaps your lordship should just look at paragraph 78.
Yep. Yes.
And so in particular in relation to little d, we would say that in light of the invention properly understood, these admissions are all that are needed to answer question 2 in the affirmative. Actavis took the additional point that it wasn't obvious that their products in advance would be soluble, but we say that is not a proper consideration when you look at the invention, which is, will it dissociate, and will you be able to get the pemetrexed to the patient?
So nothing on this page is confidential?
My lord, no.
No. Thank you.
Now, there's a slight wrinkle here, because in fact, Actavis had to apply for their liquid product as a hybrid product under the regulatory legislation, rather than as a generic medicinal product, even though they refer to generic medicinal product in this admission.
It's to do with regulatory law rather than
Yes, it's
nothing
because...
to do with nothing for us.
No, it's because their product is a liquid rather than a solid, which is Lilly's product. We say it makes no difference, firstly because the judge was proceeding on the basis it would be a generic medicinal product, as this admission sets out, and in fact it still is. It's still under the same Article 10 of the Medicinal Products Directive. But moreover, we say it's consistent, entirely consistent with the regulatory law, that different salts of an active substance shall be considered to be the same active substance. That's Article 10.2 of the Medicinal Products Directive. And we say that activists have taken advantage of that. They had to show the regulatory authority that it being a liquid didn't make any difference, but they did that without having to do any clinical work. The authorities were happy that no clinical data needed to be provided. And therefore we say that activists have piggybacked on Lilly's work to get regulatory approval, legitimately so as far as regulatory law is concerned, but as far as patent law is concerned, activists cannot say that their proposed products owe nothing to Lilly's patent.
The mere fact they owe something to Lilly's patent is a so-what point, isn't it?
It is. There's no tort of non-infringement.
No, exactly.
No,
Either they infringe or they don't.
But anyway, they admitted it in their evidence, as I understand it. They said they looked about for a method of producing the same effect with a different combination.
Indeed. Yeah, but we say it is, as far as a regulatory person is concerned, the fact that the salt is different doesn't make any difference. It's the same active substance. And we say that
simply the fact they piggybacked on your invention doesn't of itself mean that there's an infringement. No, but it is relevant. It's a relevant consideration. The fact that they are relying on the same active ingredient is a relevant consideration. We would say it's clearly relevant to question 1, which is why they admitted it. We also say it also feeds into question 2, because the skilled person would know that as well. Yeah, okay. And so, my lords, we say that the various subspecies of pemetrexed, whether it's disodium, dipotassium, ditromethamine, are merely different forms of storing the active ingredient pemetrexed before it is infused into a patient together with the vitamin B12 in accordance with the invention. And we say that is the relevant question for both Improver question 2 and question 3. So, my lords, that's a review of the patent and the activist products. I'm now going to come on to Swiss claims and address you relatively briefly on that, because in fact there doesn't appear to be very much between the parties anymore on those. In particular, the judge didn't in the end seem to rely on the word manufacturing in the claim per se. That's paragraph 128 of his judgment. But Lord Justice Floyd might have done. He said he agreed with the judge, but he also does refer to manufacturing in his judgment at paragraph 70 to 71. So I think it is necessary still to go to that and just spend a little bit of time explaining the derivation of Swiss claims. And our submission is straightforward. We say that the manufacturing wording in the claim is not to be construed in such a way that sight is lost of the real invention. The real invention is nothing to do with manufacturing. It's to do with the combination of vitamin B12 and pemetrexed. And the only reason it's there is because Swiss claims are a legal fiction invented to circumvent the prohibition against method of treatment claims. And your lordship should be aware that the EPC has since been revised and Swiss claims are now no longer allowed. So they form part of the law for almost 30 years, but they're now... So how would you now claim?
You would now claim...
For your invention in this case?
Yes, you now claim pemetrexed in combination with B12 for treating cancer.
So in other words, you can now claim a treatment?
You can.
So what's happened is not so much banning Swiss claims as permitting treatment claims?
My lord, yes, it's
and therefore,
still... It's not, the claim is not to the treatment, it's still to the product. So it's still, it's aspirin for treating heart disease is perhaps the simplest.
Well, it's an alternative use, and a new use of the same product.
Yes. I mean, that is now permitted. So in other words, what you're saying is that what's permitted is what you were really claiming in this case.
Indeed.
But you couldn't have claimed it before.
Indeed, and everyone knew that, and that's why the fact that the word manufacturing appears in the invention shouldn't distract the skilled person from thinking this is an invention about manufacturing. And
but you say that it was a legal fiction. even before the EPC was modified.
Yes,
It isn't legal fiction now.
it's not a legal fiction now because they've been
Yes.
banned.
So, all right, it's had an element of reality injected into it. But I mean, can we really construe this on the basis that a patent designed to circumvent a mandatory rule that existed at the relevant time, that aspect should simply be ignored? I mean, we might have to conclude that it did circumvent it, in which case one's not looking at a method of treatment, one's looking at a product.
Well, let me show you how the derivation came about and how other courts have dealt with this, and perhaps...
There's an element of now you having your cake and eating it. You've got to put it this way to get your patent at all. At the moment you've got your patent, you'll pretend you haven't got it this way.
Well,
that's really what's being put to you.
Well, we would say everyone recognised that this was the way to craft a claim to a use of a product, a second medical use in particular. And so people would regard this as a second medical use patent.
I understand that.
But I mean, that submission does require us to disregard the rule about patenting methods of treatment. And I question whether we can do that.
Well, with respect, my lord, it doesn't, because it's not a method of treatment. It's just as the current form of claims allow you to claim a product for treatment. This would be seen as pemetrexed and vitamin B12 for treating cancer.
That's what it says in the body of the patent.
Yes.
Yes,
That's
indeed.
quite obvious
Yes.
what the... I mean, I quite see how you say anyone reading the patent don't have to be particularly expert once you understand the problem to see what's really being claimed.
Yes.
But if you have to have the fiction for formulating your claim, it's a bit unattractive, and particularly to a court of law, saying we need to put it this way as a matter of law, and then to say, when you're looking at infringement, don't treat it as being put this way. Treat it being put this way for the purpose of validity, but not for the purpose of infringement.
We've got to assume, haven't we, that your circumvention of the rule succeeded.
My lord, yes. Perhaps I'm not directing my thoughts clearly enough. It's the invention which would be seen as the same, whether it's in the form of a Swiss claim or an EPC 2000 claim. I accept that, of course, the words are different, and there are some EPO Technical Board of Appeal cases that say it matters that the words are different.
Do you infringe claims or do you infringe inventions?
You infringe a patent, and you have to
In
determine...
order to see what the patent, whether you infringe a patent, you have to see, do you infringe a claim, don't you?
Well, you have to see whether you infringe a claim as interpreted in accordance with Article 69, and what is the scope of protection of that claim. So it comes really down to the essentiality of the manufacturing wording, and it goes to my submission that the solubility or not was not an essential feature of the invention. It was a side issue. No doubt it's important if you need to give this to people that it's soluble, but it wasn't a central part of the invention, and therefore people would not think that this issue was something which prevented something else being an equivalent if we're wrong, and it even matters that it's you have to do a simple test to get there. So.
Okay, well, tell us more about it.
I'll try and keep it brief. I think.
No, that's fine. Yep.
So, my lords, the drafters of the original EPC 1973 recognised that it would be wrong to allow patenting of methods of treatment because they didn't want doctors worrying about patents when they were treating their patients.
Yes.
So they came up with a legal fiction that methods of treatment per se were not industrially applicable. However, they also recognised that it was still beneficial to encourage the patenting of pharmaceutical products for such use, and so they created a special rule of novelty for such products as long as the use for any kind of medical purpose was new.
Is this point spelt out in your case?
It's not. This is the history. It's dealt with generally in paragraphs 38 to 62, my lord, in the case. We didn't dwell that much on the history, although Mr. Justice Kitchen did in the Rambaxi case, which we referred to, and he gives a clear explanation, which I think is the same as mine, with respect.
So it doesn't have to be, the medical use has to be new. It doesn't have to be a second use. It could be, as in this case, the primary use, because pemetrexed was unusable because of toxicity.
Yes, that's a further wrinkle, my lord. Certainly, what the drafters of the EPC 1973 did, they allowed first medical uses to be patented in this way. Yeah. But what they didn't do was allow for second medical uses to be patented in the legislation.
And in a sense, although the first medical use was probably more dangerous than curative, it was a medical use.
Yes.
Therefore,
but once you've described it as a medical use, that would destroy the novelty of any later claim.
Therefore, you have to. This is a second medical use, although the first medical use was more harm than help.
Yes.
Yeah.
Yes.
Okay.
So an old substance which had to be identified for the first time as being useful could still be patented in the form X for use as a medicament, but there was no provision allowing for second medical use, which would otherwise be invalid because the first disclosure of use as a medicament had already been made. So the way that the courts and the EPO got around this, because they recognised that research into new uses of old drugs was valuable, was to adopt this compromise of a Swiss claim to cover second medical uses, and this was a sort of second legal fiction following the first one, which they'd adopted in the EPC. And they adopted this practice of the Swiss Patent Office to write the claim as a manufacturing step for the drug for the new use. So an example would be the use of aspirin in the manufacture of a medicament to treat heart disease when it had already been known that aspirin could be used to treat pain and headaches. And this can be seen, I hope, relatively clearly from the original enlarged board decision in ESI, and perhaps I could take your lordships to that. It's at Authorities Bundle AV 3.3.
Sorry, can I have that reference again?
Yes, AV 3.3.
What does that mean? Sorry.
Authorities Volume 3.3. The electronic page is 4153.
Thank you.
And it's at tab 46 in the hard copy. And if I can pick it up, please, this is the enlarged Board of Appeal, so it's the highest court in the European Patent Office. And if I can pick it up at paragraph 19, please, which is page hard copy MS 4185 or 4153 in the electronic version.
Thank you.
And perhaps your lordships would just read 19 to the bottom of the page, and then I'll make a couple of comments on that if I may.
Sorry, 4185.
4185 hard copy.
19 to the bottom of the page.
My lord, yes, and then I'll make some comments, and then I've also got some comments on the text. On
What page do you say it was electronically?
4153.
Oh, as I thought so.
Oh, gosh.
We go quite wrong there. Okay, thank you. 19 to...
To the bottom of the page.
Right. Directed to that use.
My lord, yes. And the next sentence, if you will, as well. That's also important.
I see. And this is set out more fully, in a sense, by Miss Justice Kitchen in the...
In Ranbaxy, yes, indeed.
Yeah.
So the important part for my purposes is the very last two lines of the page where they explain that the new and non-obvious use of the known product constitutes the invention, even though it's written in Swiss form. And then they continue over the page, and perhaps your lordships would just read down to the end of the judgment before the order.
Right, the whole of that page up to the word order.
My lord, yes.
Right. Yes, thank you.
So three comments on this, if I may. They emphasise that the novelty comes from the new therapeutic use. That's the first full paragraph on the page, consistent with what they've said on the previous page about the invention.
Yep.
They also, in the middle of paragraph 22, and this is relevant to something I'm going to come to later, they explain that the principle expressio unius est should be applied with very great caution. And then finally, in paragraph 23, they explain that these claims are allowed even in a case in which the process of manufacture as such does not differ from known processes using the same active ingredient. In other words, they're explaining that the manufacturing is in fact irrelevant.
So where do you get that?
The last two lines of paragraph 23. So it just underlines the fiction that, in fact, the process of manufacture doesn't itself need to be new.
And this is the final Board of Appeal, is it?
Yes, my lord.
Enlarged one.
The Enlarged Board of Appeal. And so this is the principle whereby Swiss claims were adopted in the EPO, and this case was followed until the EPC.
Well, it's a sort of convenient fudge, really.
It is. The Enlarged Board describes it as a praetorian extension in a later case, which I'm going to come to in a moment. And I'll show you that, my lords. So this fiction was done away with in the EPC 2000. Methods of treatment are no longer deemed to be not industrially applicable, but they're still not patentable for policy reasons, which is the real reason why they weren't patentable in the first place. But there is now express allowance for the novelty of products for both first and second medical use. That's new articles 54.4 and 54.5. And if we just turn back to tab 43 in this bundle, we'll see the Enlarged Board of Appeal again in case G2 of 08. It's page 4094 in the electronic version. And this is where
the paper version, what number?
paper version, sorry, is page 4126. And this is where they are dealing with the abolition of Swiss claims and the new form of claims and explaining how they're to be dealt with.
Right.
And so if paragraph 87 is relevant, perhaps your lordship would just look at that.
I mean, as a matter of curiosity, why praetorian?
Yes, quite.
Well,
As a matter of etymology.
I think it unprincipled. I think that's the.
Unprincipled.
I've struggled with this a little as well. I
Just
thought
a word for fudge, really.
No, the pretor was used to develop by adding, Lord Hodge will know better than I, comments to, for example, the code, the previous code.
He'd rule rather like the Lord Chancellor. He liberalised the law.
Well, that's no doubt the reason they used it, and that's.
He said quickly.
Yeah.
Depends how much
I had looked it up and failed to find a proper explanation. So
depends how much Roman law you did at
indeed, I'm afraid
university.
Most
Anyway, it's
of the
nothing to do
scientists
with
on this side of
bodyguards.
The analogy
I have
of the
to
Lord
say that
Chancellor only goes so far.
my knowledge stops with the Praetorian Guard, like Lord Sumption's, I think.
I think Lord Hoffman would know a lot about the Praetorian extension.
I'm sure. My lords, that's paragraph 87, and then paragraphs 106 and 107, where they go into this in a bit more detail, and they explain that in their view there is no difference between the old Swiss claim and the new claim, that is to say, aspirin for treating heart disease.
Paragraph?
Paragraphs 106 and 107
Sorry.
on page
Yes, I have it.
4097 electronically, or 4129 hard copy.
Well, none that can't be supplied by decent advocacy.
Yes. Thank you.
So here they're referring to the Travo, and they point out that the Travo explain that the protection is equivalent, and that it's intended that the limitation is intended to match as closely as possible the scope of protection to the scope provided a Swiss-type claim. Then 107, they explain that the case law should be enshrined and to keep the legal status quo for medical uses. So, my lords, in our submission, it's clear from this that the new form of claims are meant to be understood in the same way as the Swiss claims. That is to say, the manufacturing wording should be ignored, and that the skilled person would understand this as being a claim for pemetrexed and B12 for treating cancer, and they wouldn't dwell on the manufacturing wording. And this is particularly given the comments of Mr. Justice Kitchen in Rambaxi and the Court of Appeal in Virgin, that the skilled person does understand the drafting conventions in patents, and therefore would understand this was a legal fiction, and therefore this was in reality a claim to pemetrexed and vitamin B12 for treating cancer. My lords, I acknowledge that there are a couple of more recent decisions that point out that the wording of Swiss claims is different to the wording of the new type of claims, which of course it is. These observations are only so far from the Technical Board of Appeal. There's no enlarged board decision dealing with this. But in any event, we say it's clear that even the Technical Board could consider that the underlying invention is the same in both types of claim, even if the form of the claims is different. And we say that's good enough for our purposes, because what's important here is recognising what the invention is. It's a new combination and nothing to do with manufacture. Finally, on this point, my lord...
Can you just give us the reference to those technical cases?
Yes, my lord. They're in my learned friend's case, and my learned junior will give you the paragraph numbers of his case to refer to. My lords, the final point on Swiss claims is to take you to the Bundesgerichtshof and show you what they say about Swiss claims. We say that's entirely consistent with the position that we adopt.
Yep.
My lords, this is in Core Volume 2, tab Q.
Thank you.
And this is the Bundesgerichtshof decision in this case between Lilly and Actavis in Germany. Yes. If we turn all the way to the end of the decision, it's page 718 in hard copy, 721 if you're on the electronic version.
Thank you.
Although this part of the judgment is dealing with secondary infringement, it does deal with the meaning of Swiss claims and is pertinent. And it's paragraphs 83 to 85. Perhaps your lordships would just read those paragraphs.
Yep.
So my submission is this. They start off talking in paragraph 83 about new form of claims, the suitability of a substance for a specific medical purpose. And they say how that should be construed. And then in 84, they say the same applies to claims which, in accordance with the previous legal practice, are aimed at the use of the substance for manufacturing a drug. What's important is the last line of 84, a particular property of the substance is protected, which is also inherent to the drug manufactured. And then they contrast this with the more literal understanding of Swiss claims in 85. They say a different assessment would not be conceivable even if Swiss claims were to be deemed to be manufacturing type claims. And so, my lords, we say that shows that the Bundesgerichtshof clearly don't place weight on the manufacturing wording. My Lord Clark asked about the other cases in the EPO. These are dealt with in paragraph 34 of my learned friend's case in reply, and they can be found AV3 tabs 44 and 45. But in my submission, all they show is that the EPO at the TBA level is distinguishing between the form of the claims to say there is no double patenting by having a Swiss claim and a new style claim, because one is said to be a product claim and the other is said to be a process claim, and their scope may be slightly different because of that. We say that makes no difference to the invention underlying the claim, and indeed the TBA says expressly, I think it's in paragraph 13 of the first of those decisions, that the invention is deemed to be the same.
Yep.
So, my Lords, that's all I intended to say on Swiss claims. And now I was going to move on to look at the legislation which we're concerned with, Article 69 and the protocol. And your Lordships probably haven't seen those set out in the form in the legislation, and that's to be found at AV1, Authorities Bundle 1, tab 1.
Sorry, where is it?
Authorities Volume 1,
Yes.
tab 1.
Thank you. Yes.
And it's physical bundle, page 2366, electronic bundle 2389.
Thank you.
And there we see Article 69. So this defines the extent of protection of the patent.
Yes.
And as will be familiar, the extent of protection conferred by a European patent or an application shall be determined by the claims. Nevertheless, the description and drawing shall be used to interpret the claims. And then we have in tab 2 the protocol on the interpretation of Article 69, electronic bundle, page 2396. And again, your Lordships will be familiar with the wording there, but perhaps it's convenient to look at it again now.
Yep.
And which MS number 1?
It's electronic 2396, physical 2373, tab 2.
Thank you.
Is this contemporary with tab 1?
My Lord, yes. These should both be the updated EPC 2000 version.
Yes, but they were both issued at the same time, weren't
They were, yes, as part of the Munich conference in 2000. And so what has changed, the material change as far as the parties are concerned between EPC 1973 and EPC 2000 is the addition of Article 2 equivalence in the protocol in tab 2. And we say that makes express that as part of the process of determining scope, the court should consider if any element is an equivalent.
But this was there's a principle of equivalence existed before that, did it?
It did. I'm going to show your Lordship why Article 2 was added, because it was felt that the principle wasn't being adhered to sufficiently, partly because of the different results that had arisen in the improver or epilady litigation throughout Europe. In the UK, the patent was found non-infringed, but in Germany and the Netherlands, it was found to be infringed. And it was thought as a result of this that the courts in Europe were not applying the same test. And so Article 2 was added to the protocol. And I'll show you that.
You say they were trying to bring the UK courts into line with the Netherlands and Germany.
Indeed. And I'll show you that expressly now. Just before we go to that, of course, this has been transferred into the domestic legislation, but because, and it's section 125 of the Patents Act, but that section is said to have the same effect as the European Patent Convention pursuant to section 137. So we say it's not necessary or helpful to look at the domestic legislation because that effectively refers you back.
Just give us the reference.
Yes, it's 125 of the Patents Act defines the scope of protection, but section 130, subsection 7, says that section should be interpreted in line with the European Patents Convention.
Yeah.
So, my lords, legislative history, we have set some of this out in our case in paragraph 70 to 81, and I don't propose to go over it in detail, but I do want to highlight a few points, if I may. Firstly, to give you some assistance as to what is meant by the two extremes in the protocol through which you're meant to chart a central course. If I may, the best place to see this is in an article written by Professor Laddie, to which we've referred, and this is in Authorities Bundle 4, tab 5.
Thank you.
And the section I would like to take your lordships to is the section on page 4342 in the hard copy, or 4311 in the electronic, where Professor Laddie talks about the legislative history. This is tab 5 of Authorities Bundle 4.
Yep.
And it's page MS 4342 at the bottom in the hard physical copies.
Thank you.
And so what Professor Laddie does, he starts to summarise the legislative history, and he explains there are other sources you can go to. But then he says, second sentence in paragraph 71, as is well documented, Article 69 EPC was derived virtually verbatim from what became Article 8.3 of the Strasbourg Convention on the Harmonisation of Substantive Patent Law. And he then goes on to discuss how Article 8.3 was derived, because he says that's where Article 69 came from. And he deals with this on the following page. And perhaps your lordships would just read paragraphs 73 and 74, please.
The essential idea, yep.
Well, my lords, so first of all, in 73, he sets out the Travo set out the three options, and they go for the sort of the Goldilocks version, the one in the middle. That's
Yes.
number 3. But in particular, we rely on the particular observation in 3 that this needs to take into account the applicant's difficulty in wording the patent claim so as to cover all conceivable embodiments, including those not even known at the time of the application. Yeah. And then that is then repeated in the report in the excerpt in paragraph 74, and at the end of that paragraph bridging the page, the omission or addition of certain features which do not affect the substance of the invention claimed, or the substitution of given features for equivalent features does not invalidate the protection. But then they go on to say the only exception is where you have effectively disclosed but not claimed something, disclosed in your specification but not claimed it, and that is, as we shall see, the doctrine that's been adopted in Germany and the Netherlands, which I referred to earlier. And we say Actavis's position is effectively you should neither have protection for the things that you have disclosed but not claimed, nor should you have protection for things that you haven't disclosed either. We say that effectively rules equivalence out altogether, because there's nothing left that you could have as an equivalent. So these policies were taken forward into the Strasbourg Convention. They were then taken forward into Article 69, and Professor Laddie describes that in paragraphs 75 to 77. I don't think we need to look at that in further detail now. But while we have this article open, could I also direct your attention to paragraph 80, where Professor Laddie goes on to talk about the effect of Kieran Amgen. And perhaps your lordships will just read paragraph 80, please. So we emphasise the observation that if too strict an approach is adopted, then the patentee is expected to be not only a faultless draftsman, but also totally prescient. Professor Laddie there refers to an article by Professor Meyer-Beck at footnote 93, and I'd like to show you that as well, if I may, to give you the German perspective on this. That is at tab 8 of this bundle.
Right.
And just to remind your Lordships, Professor Meyer-Beck is currently the presiding judge of the Patent Senate of the Bundesgerichtshof, and he sat on the German equivalent of this case. And this was an article he wrote in 2005. And if I can pick it up on the second page of the article, bundle number 4393, and perhaps your Lordships would just read the paragraph in the middle of the page, beginning unfortunately, just down to the first sentence of the next paragraph. So again, Professor Meyer-Beck's emphasising if a too literal an approach is adopted, then this is harsh on the patentee because it will be easy to bypass the invention because the patentee's imagination is usually not sufficient to foresee all and every possible case where a competitor may deviate. And then he goes on a similar theme on the following page, and if your Lordships would be so good as to read from the top paragraph 2 down the next 3 paragraphs.
Well, because down to at all.
Yes, please, my lord. So, my lords, he again specifically identifies the purpose of equivalence as being to provide protection to a patentee for material which is obvious, but which the patentee did not, for whatever reason, write down in his description and claims, either because his imagination was not sufficient to foresee all possible workarounds, or because his drafting wasn't perfect. And he points out that the notion that the claim should cover all non-inventive variants viewed through the eyes of the notional skilled person is not unfair, because the patent is liable to be revoked for obviousness for the same reasons, and therefore an equivalent test of is it obvious in the light of the common general knowledge to the skilled person is a fair test to apply for the purposes of obviousness and also for the purposes of deterrence.
However, the relevant skilled person regarded as wholly unobvious.
Yes, my lord, in drafting the particular patent, because not all...
If it's objectively obvious, it's objectively obvious.
My lord, yes, and that's the simplest way to determine this, because it's the same test as you use for obviousness to determine the validity of the patent. So the court is adopting the same mantle with the same information before it and asking a very similar question. Now, my lords...
So how do you apply that here?
Well, you say that the claim covers all obvious variants. That's what...
Obvious to try.
Obvious to try, including obvious to try, absolutely, my lord. That's
all variants which it would be obvious to try and which prove to work.
My lord,
Yeah, well,
yes.
not much use
Doesn't
covering
matter if they
once
don't
again,
prove to work. Right?
No, so subject, of course, to the... It's still possible for there to be an express disclaimer in the patent to limit it. But that is certainly the view of Professor Meyer-Beck, was that is a suitable approach to take. And rather than, he prefers that approach to the purposive approach of what is the patentee thought to have meant in writing the claims, and he does contrast those two approaches and says that the obvious to the skilled person is the preferred approach for the reasons he gives. But in any event, my lords, we certainly, even if that's not...
Unless it's expressly excluded.
Unless it's expressly excluded.
Why would you ever expressly exclude it?
Because you might know that there's some prior art out there which you don't want your patent to cover, because if it covers some prior art, then it will be invalid. So you'll say, well, I'm deliberately not trying to claim potassium or some sort of pemetrexid because I know that already exists. In fact, none of that, of course, has arisen in this case because activists have not challenged validity for their own tactical reasons, and they withdrew as TEVA from the appeal that they had in the EPO Board of Appeal.
In this case, it might be quite hard to think of something, but in other cases, it wouldn't.
Indeed. And we say that's the effect of Article 2, to make the skilled reader think about equivalence and consider that inessential variants are to be covered, perhaps essential material variants are not. That's how Lord Justice Aldous put it in Wheatley and Drilled Safe.
So it's got to be inessential and obvious.
My lord, yes.
Those are the two ingredients.
Yes. And we say both of those apply in this case.
So it was obvious to try something other than pemetrexid with vitamin B12. That the fact that it would be an obvious idea wouldn't make it an infringement because it would be replacing an essential ingredient.
My lord, yes, that's a very different set of facts.
Oh, of course.
Yes. Yes.
I'm just trying to see where this goes.
Yes, and that's similar to the fact scenario in the American Home Products case. Rapamycin was what was claimed as the new ingredient,
right.
And the variant was a different form with a different chemical group on.
Whereas the potassium or the sodium is simply a sort of wrapper.
My lord, yes, and in the American Home Products case, it was said there would have to be clinical trials to prove that the alternative worked, and indeed the Court of Appeal said it would be insufficient. The patent would be insufficient if it covered that alternative because it was so much work to decide whether or not.
I wondered whether that was another reason for excluding certain things would be insufficiency as well as obviousness.
Well, yes, that's obviously something that the patentee needs to consider. But if it's obvious alternatives, then it can't be insufficient because it's routine to find those. Now, my lords, in response to these articles, activists say, well, they're out of date. We don't understand that because nothing's changed since they were written in 2005 and 2009. Nothing material has changed. Activists also seek to rely on the views of Sir Robin Jacob in the article at tab 3. With respect, we say they don't support activists because he doesn't, in his article, deal with Article 2 to the protocol. And even then, he acknowledges that there are continental judges who think there is a doctrine of equivalence and there's still a debate to be had as to the correct approach. So, with the greatest respect, we say that doesn't help them. So, my lords, that's the background to Article 69 per se, and we've also provided in our case some background, the travo to the development of Article 2 of the protocol itself. And again, I'm not going to take you through every twist and turn of the drafting process. Those have been set out in both parties' cases, but I would like to just make the following points. And I think what is not in dispute is the amendment to the protocol was made because it was thought that the application of Article 69 and the protocol was not sufficiently uniform. There's a definite treaty intention which you are permitted to take account of, which can be seen in the travo. And if I can show you just a couple of documents in relation to the EPC 2000. Firstly, Authorities Bundle 2, please, tab 19.
Right?
So this, you'll find the basic proposal that was drawn up by the President of the EPO to the Committee of Patent Law, which is one of the two organs of the European Patent Organisation alongside the EPO, and it is the committee advises the Administrative Council on possible revisions to the EPC. And if your Lordships would just read the reasons for the revisions suggested on page 1.
Right, yep.
And then you
The
can
point
see...
you were making, you're saying.
I'm sorry, my lord.
It makes the point you were making.
Yes, indeed. And then you can see the revised wording on page 2, which is not the same at this stage as the wording that we've ended up with. And you, just to explain the differences, you can see in little paragraph 1 on page 2, at that stage, it was going to be suggested that equivalence should expressly be determined at the time of the alleged infringement.
Yes.
Secondly, there was a definition of equivalence in paragraph 2, which reflects much of the discussion we've already had. It would be obvious to the person skilled in the art, achieving substantially the same result as that achieved by means of the element expressed in the claim. Yep. And then finally, there was a provision in relation to prosecution history. 3, you'll see that it was suggested that where statements had been made unambiguously limiting the extent of protection, in particular where the limitation was made in response to a citation of prior art. So those were the 3 original provisions. And we see how they were discussed in the next tab, the minutes of the committee meeting in Munich in July 2000 of the Committee on Patent Law. And perhaps your Lordships would just read the minutes, paragraphs 227 to 233 on pages 39 and 40 of that document.
Is Epilady improvement?
That's improved, my lord, yes.
Thank you. Yes.
So, my lord, we submit that it's clear from this that the changes were proposed to focus on a broader doctrine of the scope of protection, and Article 2 was inserted to try to harmonise the UK with the rest of Europe by encouraging the UK to be less literalist, as it was thought it had been in the Epilady case. And this form, or materially the same form of provision, was taken forward to the diplomatic conference in November 2000. At that diplomatic conference, the UK's primary position was that there should be no amendment to the protocol at all. And we can see that set out in tab 27. I don't need to go to it now.
Right.
The UK and Sweden suggested there be no amendment. That was voted down. And so a classic diplomatic compromise was come up with, and Germany, the France and the UK proposed jointly the version that we now find in Article 2
right.
As being what should go forward. They dropped the reference to prosecution history. They dropped the reference to the definition of equivalence, but we now have the version that we have that was approved at the diplomatic conference.
But what was dropped, as I understand it, included the reference to at the time of the infringement. Yeah.
Yes, my lord, it was.
Yeah.
Yes.
But that's fairly critical, isn't it?
It's not critical to my case today, my lord. It's certainly part of what could be said to be the right approach, and it's the approach that the Dutch take.
Well, it would be critical if you turned out to be wrong in your suggestion that the solubility, the known solubility of other salts at the time of, in 2000, was...
No, with respect, no, my lord.
You took us the passage in the judgment that said it was known that there would be other...
My lord, yes, absolutely.
But I mean, I think
2000.
the point made against you is that what wasn't known was that the particular salt used by Avantis was soluble. Now, I appreciate your submission is that that is immaterial because it's a routine test. But if you are wrong about that, then it does become critical.
If I'm wrong about that,
to look at the time at which you look at these matters, whether it's at the time of infringement or in the priority date.
My Lord, if I'm wrong about that, that's correct. But with respect, that would revolutionise patenting of empirical art, because it would mean you could get a patent on in any empirical field just by doing something which you don't know until you've done the experiment is the right result. And that's clearly not the law. We say in terms of obviousness, we have the skilled person is permitted to do routine tests for the purposes of obviousness, for the purposes of sufficiency. And indeed, we refer to the Hospira.
I agree, obviously, if they are indeed routine tests.
Yes.
But I'm not sure that's accepted by your opponents. Maybe it is.
Well, I think the judgment records that you would have a good expectation of finding an alternative, and the judgment also records that the tests are routine. So, my Lord, I don't think that's in dispute.
I think you took us to the passage.
I did. And of course, you have to have the infringement in mind when you're trying to determine whether or not it infringes. So, in some senses, you cannot be stuck at the priority date because you are deemed to know what the infringing item is. And really, this case, as far as question 2 is concerned, just turns on how much information you have. Do you know that it's soluble because you can see it's soluble? Or if you don't know it's soluble because you're given a bit of paper with it written on, are you allowed to do a simple test to find out that it's soluble? And we say in both those cases, it is obvious, it's routine to find out, and that would satisfy the test. And we say that's consistent with Improver, in fact, and I'll come to that a little bit later and show you the passages in Improver we rely on. So, my Lords, in terms of, that's all I need to talk about in terms of legislative history. We don't say that there was any express agreement by the UK to abandon purpose of construction. We're just using the legislative history to show the purpose of the legislation and that all states, including the UK, must now take due account of equivalence. We don't shy away from...
Trying to establish equivalence between the different jurisdictions.
Well, my Lord, yes, I appreciate that. Because the definition was removed, we have that to determine. But I think it's fairly clear. We'll come on to talk about precisely what that means. We don't shy away from the fact that this does make it more difficult to interpret the scope of the claims, because there is undoubtedly a loss of certainty. But Article 69 acknowledges that, and as long as there is still a reasonable degree of certainty, and we say that is provided by our proposed test, then it is part of the necessary balance in providing fairness to the patentee. And the legislators have determined that this is a price worth paying for the policy reasons I have touched upon. Now, Actavis and the courts below, we say don't give proper recognition to this policy, and that's one of the reasons they fall into error. Actavis also suggests that the direction of travel has been towards and not away from the UK since Improver. And it's right, of course, that the international courts have sought to be respectful of each other, and indeed continental courts have considered Improver and Amgen in deriving their own approaches. And there are substantial similarities between the approaches adopted, but there are also significant differences. In particular, many, if not all, of the continental courts adopt a two-stage analysis, asking first whether there is literal infringement, and then separately whether there is infringement by equivalence. And, my Lords, we note that Actavis submitted to the Court of Appeal that there ought to be a consistent approach across Europe, and if that is so, we say that helps us, not them, because it's clear that there isn't a consistent approach at the moment. And it's for that reason that we say that if we're right about the UK, then the same result should follow in France, Italy, and Spain, where we say, particularly in Spain, the same approach as the UK is adopted. So it's with that in mind that I now turn to those jurisdictions to show you what the tests are there. My Lord, the judge set out his analysis of the approaches, and he identifies the two-stage approach in each of France, Italy, and Spain, and he talks about literal infringement and then infringement by equivalence. And the difference we would submit with the UK is that the claim is first construed in context, and then the issue of whether its scope also includes equivalence is asked. And this two-stage test sets up an express balance between legal certainty for third parties, that is the literal wording, and protection for the patentee, which must be fair, that is the equivalence aspect. And so it can be helpful to do it in a two-stage approach just to see where the boundaries are. As far as the foreign law is concerned, I think the simplest and most concise statement of approach is that set out in our Notice of Appeal, which is at Core Volume 1, Tab 2.
Page.
Page 53 in the physical bundle and 56 electronic.
Thank you.
And perhaps your lordships would just like to remind yourselves of paragraphs 26 through to 35, and then I've just got a few comments to make on that.
You want to sit down while we read them, feel free.
Oh, great.
Yes.
So if I may break it up into smaller chunks, France and Italy, we submit, are similar, take those together. As Lord Justice Kitchen observed in the Court of Appeal, there's no clear equivalent to improver question 3 in those countries. And significantly, Actavis conceded that their products were equivalent under Italian law to the Lilly product, and it was only the judge's incorrect reliance on prosecution history that we say saved Actavis in the judge's judgment. That's recorded at paragraph 178 of the judge's judgment.
Sure.
In Spain and Germany, more attention is paid to a structured improver type approach, but as I've said, there are differences between the approach in those countries and the approach in the courts below here, and that's perhaps best illustrated by the approach of the Bundesgerichtshof in the present case. I've shown you that already, but if I may show you another passage from that judgment. It's Core Volume 2, Tab Q. And physical page 713, E-bundle 716. And if your lordships could just read paragraphs 60 and 61, please.
Sorry, page?
Page 713.
713. Yeah.
So, my lords, they are talking about the equivalent to question 3 here, but they refer to the discoverability principle of question 2 as well. And they explain here that if, under question 3, you were to exclude both those things which were in the specification but not in the claims, and also those things which were discoverable on the basis of the statements in the patent specification, then that would be going too far, because discoverability is a basic requirement for establishing the existence of equivalence in the first place. And if you were to use discoverability as a reason to exclude under question 3, then you could never have a patent infringement by equivalent means, which chimes with the submission that I made to you a little bit earlier.
I see. Yes?
Now, unsurprisingly perhaps, there's an attempt by Actavis to downplay the impact of the German approach in the light of this decision, because they reversed the Court of Appeal in Germany on question 3 and have remitted it back to the Court of Appeal on questions 1 and 2. They say there's no reason to pick Germany over any other jurisdictions, but we do point to their submission made at the outset of this case, the original jurisdiction hearing, where they said that of the foreign jurisdictions, Germany was obviously the most important, because German patent law is very well developed. My Lord, we say they were right about that, and that your Lordships, as you have done in the past, in the Schutz case, for instance, you should take note of the approach.
Well, yes, in the Schutz case, there was a decision of the German court on the very patent.
Yes.
Practically, you can say that's true here.
Yes, well,
but here, if we're looking at principle, it's slightly different.
Yes, my Lord, of course, it is principle which you should be primarily concerned with, not result. But we do say that as a matter of principle, it's clear that the German court's approach is different under question 3. And of course, we say the Bundesgerichtshof say we win under question 3. And even under question 2, it's clear that a different approach is adopted, the discoverability principle. And although it's right that there is no outcome in Germany yet, because the Court of Appeal have been asked to determine questions 1 and 2, we say that, as we've seen, they've already held that it was discoverable under question 2, and therefore it's very likely they'll do so again. And if it's needed, the approach in Germany can be best illustrated by the questions that the Court of Appeal in Germany have asked the court expert, and those are in bundle Authorities Bundle 5, please.
Yep.
It's tab 4.
Yes.
Starting on page 4453, and then on page 4455, you'll see the questions that the court has asked the court expert.
Number are we on the electronic one?
On electronic version, it's page 4425.
Thank you. Yep. Yes.
And it's little a and b on
Yep.
page 4.
That's the use. Yep.
Yes.
Yep.
We say on the application of that test to the facts as found by the judge in this case, we would win in the UK because the skilled person would expect to find an alternative. It's discoverable, and the SALT screening test that they would carry out is routine.
That is the test you're inviting us to apply on the question of direct infringement.
My Lord, yes, under question 2, yes.
On question 2.
Question 2, yes. Finally, as far as comparative law is concerned, activists have raised the Netherlands as an example. But with respect, we say that's supportive of Lilly's case, not of activists, if your lordships are interested. Activists rely on an article by Rianne Kaldum, who is head of the IP division in the Court of Appeal in The Hague, and her article is at tab 4 of Authorities Bundle 4. I'm not going to go to it, but if I can just tell you the points that Lilly she says, particularly on pages 4352 to 4354 in the electronic version.
This is the doctrine of equivalence, is it?
It is doctrine of equivalence, my Lord, yes.
431A, yeah, thank you.
She emphasises the importance that the inventive concept plays in the process of construction. She is absolutely clear that the exercise of construction is different to the exercise of determining equivalence. She addresses them under two separate headings. She explains, as I've mentioned, that the courts are allowed to take into account after acquired knowledge, that is to say, the common general knowledge at the date of the infringement. And she says that the infringement doesn't even need to be foreseeable as far as Dutch law is concerned. And she also refers to the established principle of construction, disclosed but not claimed, which we've already looked at in the Travaux and the German cases. And if that approach is right, it means that equivalents are really directed to features which had not been expressly contemplated by the patentee in the specification, and we say that's this case. So, my Lord, we say if you wish to look at the Netherlands, then her article is helpful and supports Lilly's approach.
Right. Yep.
So, my Lord, I think that takes us on to the approach in the UK hitherto, if I may. We set out some of the older cases in our written case, and we referred to Lord Reed in Van der Lely at paragraph 67. That's not because we're suggesting that we should revert to the doctrine of pith and marrow. We're just attempting to show that the policy reasons justifying equivalence have always played a part in English law, and there's no reason to be cautious about accepting them now that they are expressly required by Article 2. At paragraph 82 of our case, we discuss Catnick, and I would like to take your lordships to that if I may. This is in the Authorities of Volume 1 at tab 4. This is, in particular, the speech of Lord Diplock in the House of Lords. And I want to pick it up, if I may, on page 241 of the report, 2449 of the physical bundle, 2472 of the electronic bundle. And your lordships should see there a diagram of the issue that was before the House of Lords in this case. The patent claim referred to something being vertical, and the alleged infringement was at an angle of 6 degrees, and the question was whether or not that was an equivalent and fell within the claim to vertical. And perhaps your lordships would pick it up, just the last paragraph on page 241, beginning, "The invention is a simple one," yes. And read what Lord Diplock said there. One could make a wry observation about the quality of Lord Diplock's builders, but certainly he thought that it would be obvious. Any knowledgeable builder would know about forces, certainly in those days.
And any builder would know that the load-bearing capacity proportionately reduced with the cosine of the angle of inclination.
Indeed.
Yes. Very, very special kind of builder.
Well, that sets
He's one of Lord Macaulay's schoolboys.
Yeah. Any fool now, yes. Molesworth, yeah, okay.
And then he deals on page 242 with the judgment of the Court of Appeal. And then in the level with the second hole punch, line 25, he makes, perhaps your lordships would read that paragraph, "My lords, in their closely reasoned written cases."
Extraordinary man, Lord Diplock.
Yep.
So this is really the derivation of the one-step approach as opposed to the two-step approach. But of course, in those days, it has to be remembered, there was no statutory definition of infringement. And so the courts were grappling with a somewhat more inchoate principle. Then at the bottom of the page, we have the familiar passage beginning, "My Lords, a patent specification." Perhaps your Lordships would just read that. Remind yourselves of that.
Well, that paragraph.
My Lord, yes.
Yep.
So the upshot of this is patent specification should be given a purposive construction. Meticulous verbal analysis should be avoided. The question in each case is whether persons with practical knowledge and experience of the kind of work in which the invention was intended to be used, i.e. where the invention is intended to be put into effect, would understand that strict compliance with a particular descriptive word or phrase appearing was intended by the patentee to be an essential requirement of the invention, so that any variant would fall outside the monopoly claimed. And I do emphasise, my lords, that any is in italics in this passage. It's often not recorded when this passage is reproduced, but it seems to in my submission at least, that what Lord Diplock was intending to emphasise was, do you think that there's strict compliance so that any variant should be deemed to be falling outside the monopoly claimed, even though it could have no material effect upon the way the invention works? And we would say that properly understood, that amounts to presumption against excluding non-essential variants, because it would be surprising, as we see Lord Diplock express on the following page of the report, if the patentee didn't intend to include immaterial variants within the scope of his monopoly. So, my lord, that's...
This wasn't, although the Patent Act was in force by the time it even was had by Miss Justice Whitford, this was not a Patent Act.
No, this was in 1949.
It was
This
under the 49 Act,
yes,
not under the 77 Act.
Yes, and we explain how, in the Improver case, the Court of Appeal on the interim injunction application in Improver said that this was to be the approach under the EPC as well.
Right.
And then Lord Hoffman then applied that at the trial. We'll come on to that in a moment. So, my lords, that's 243. And then on 244, Lord Diplock applies these principles to the facts of the case. And perhaps your lordships would just read the first two paragraphs on 244, starting the essential functions. Essential features.
Essential features.
Yeah.
I mean, if one adopted the German approach, one would not be regarding this as a question of construction at all.
Indeed. And
it's a bit difficult to see how vertical can mean non-vertical.
Yes. Apparently, Lord Diplock it does, but that's to a builder who
Well,
knows about
obvious to a builder,
cosines.
yes, well.
Well, I mean,
And it might be obvious to a builder that it didn't matter, but it wouldn't be obvious to a builder that it meant the same thing.
It may be easier, of course. Vertical could be said to be a word of degree. Certainly, it has been characterised in that way, or this case has been characterised in that way. But that's
a bit pregnant, a bit vertical.
Yeah. The other observations to make about this passage: firstly, there's the nutshell question that Lord Diplock has at line 6, which is a way of trying to ask the question in one go. Although, with the greatest respect, it's got a couple of double negatives in. It's quite difficult to apply it in one go because of the complexity. But there's the passage at line 14 where Lord Diplock says, no plausible reason has been advanced why any rational patentee should want to place so narrow a limitation on his
That's a
invention.
very dangerous line, isn't it?
Except that he did.
Exactly.
But it also,
You
it
took about a
echoes...
week to work out what he was talking about in the middle of it.
Well, the trouble is that can always be said if somebody comes up with a variation that doesn't fit the words.
Yes, the only point I was going to make on this, my Lord, was Lord Diplock would have been aware that a slightly broader claim would be more liable to being said to be invalid.
Right, well, that can always be said.
But that wasn't something that so it could always be said. If it could always be said, it's always a reason to exclude equivalence, and we say that's not the right approach. So all I'm commenting on is he didn't seem to be concerned by that, and if you place too much weight on this faux concern, we say you would read equivalence out in every case, because you say, well, the poor patentee, his claim might be invalid if I say it's any broader than the...
Was the strict interpretation plus equivalence argued on behalf of the patentee? Or was it simply treated as a question of construction?
That's a good question, my Lord. I don't know the answer offhand. We'll look at the reports of the arguments are reported here.
I mean, it does, yes.
I think the pith and marrow doctrine was relied on.
Yes. There's a pith and marrow sort of...
But we've really got, in order to accept the essential submission that we make, we have got to depart from the suggestion that this is actually a question of construction at all and adopt the two-stage approach, haven't we? Because it's only a question of construction if you take a really extremely artificial view about what construction involves.
There's no way that sodium can mean potassium.
No, well that... As we don't say that it does.
No, I know.
Literally construed. It all depends.
Well, even unliterally construed, it's very difficult to say.
If we're going to be intellectually honest about this and admit what we're doing, we've basically got to say this is a second stage, which comes in after you have construed the thing, not necessarily literally, but certainly construed the language and not what language it might have been more sensible to use.
My Lord, that would be the approach we would say is. It of course all depends what you mean by construction, which I think is what my Lord Neuberger observed in Marks and Spencer and Paribas, and so one can characterise the whole exercise as an exercise of construction and carry out the iterative process of including equivalence in that.
That would mean that there was a special rule for interpreting patents, wouldn't it? It's very difficult to think in any other world sodium would include potassium, however you...
No, I mean, and we don't say there's any difference to construing the words of the document.
Right.
It's the same as any other document that comes before the court. But in patent law, you are required, in addition, to take into account equivalence, and that's the difference.
But so that's not a question of construction at all.
No. If on your case, but then you have to get over what Lord Hoffman said in Kirin-Amjan.
Yes, which I'm.
But if we depart from Lord Diplock, it shouldn't be any more difficult to depart from Lord Hoffman. The origin of Lord Hoffman's analysis in Amgen is actually this treatment of the thing as a single-stage process of construction, isn't it?
Yes.
It's Katnick, improver in the Court of Appeal, dictating him Lord Hoffman as Justice Hoffman, an improver at first instance.
Yes.
Who then you say perpetrates that approach. Yes. You don't accept necessarily he does, but it might be said that he perpetrates that, continues that approach in Kirin-Amjan.
Yes, I suppose two additional comments. Firstly, we don't suggest that, in fact, Lord Diplock's approach, apart from whether you call it construction or not, his approach is consistent with the EPC 2000, because he clearly takes into account equivalence, and he finds that something that isn't strictly vertical still falls within the claim. And we say his reasoning for doing so, the top of 243, is good today under the EPC as it was then. The other difference is that there is a subtle difference in change in wording as we go from Katnick to improver, which I'll show you, and it's characteristic of Lord Hoffman's more linguistic approach. So he treats it as a...
Lord Diplock, in the middle of 2452, goes into the linguistic point, doesn't he? He says effectually vertical is a fudgy word and capable of expansion.
Yes, it's easier to do that with a word that could be said to have an element of degree in it.
Well, the problem about this whole analysis is that it fails to distinguish between what the words mean and whether it matters in the relevant respect what they mean.
Yeah.
And the latter is nothing to do with construction. It may have quite a lot to do with equivalence.
Yes.
But you say that the EPA and the protocol do just that. They drift, starting off on the basis that the extent of protection is determined by the claims. They then said you mustn't go to either Scylla or Charybdis in construing the claims. And then Article 2 actually says you should take due account of any element which is equivalent to an element specified in the claims. And so by definition, you're looking at something which is not covered by the wording of the claims.
Correct.
And indeed, I mean, the German and the French seem to say precisely that. They say the
Yes.
German actually uses the word not named, and the French not indicated in the claims. So, I mean, all right, it's a
relying
drift
only on
of meaning.
equivalence, aren't you?
Yes, my Lord.
You're relying only on
I am.
equivalence, not on construction.
Correct.
So Lord Diplock, by taking what he calls the purpose of construction, achieves what you say is consistent with the EPC 2000, but it would be much clearer if you had a two-stage process.
Absolutely, as the other continental courts approach it.
Yes.
Well, I'd like to see that.
Yes.
The extent to which the continental courts do that.
Yes. Well, one can see the best example is perhaps the German courts. The judgments are distinguished. They have a section on literal infringement, then they have a separate section on equivalent by.
Can you show us that either in this case or some other case?
Yes, in this case, certainly in the of course the
You want to do that
Bundesgerichtshof only look at question 3. So perhaps if I over lunch I'll
if you would,
come back
thank
to that if I may. Tab 5 is improver. And if we can pick it up at page 188, which is the section on infringement, the physical bundle, page MS2461.
Sorry, which bundle?
Sorry, in the same bundle, AV1, Authorities Volume 1, tab 5.
Tab 5. I see, the very next case, yeah.
Yes. And this first sentence really encapsulates the problem as we see it on page 188 under the heading infringement, where Lord Hoffman asks, the question of infringement turns upon a short but undoubtedly difficult point of construction, namely whether the rubber rod is a helical spring, as that expression is used in the claims of the patent in suit. And we say this creates the problem because it is very difficult to say that a rubber rod is a helical spring as a matter of language, just as it's difficult to say that pemetrexid disodium is pemetrexid dipotassium as a matter of language. We acknowledge that face on. Now, Lord Hoffman does acknowledge the other approach, which Lord Justice Dillon adopted in the Court of Appeal, as to whether or not something is a mechanical equivalent. We say that is the sort of two-stage approach that we submit as the right one, but he goes on to say he thinks it's different ways of saying the same thing, and our criticism of this approach is that it, if you adopt a former linguistic approach, then you end up with a narrower construction, a narrower scope overall, because you get so hung up on the words, as lawyers are wont to do. Now, my lords, the familiar passage is then set out at the bottom of 188. And perhaps your lordships would just remind yourselves of bottom of 188 to the middle of 189, and then I'll
That's just for Catnick. Right?
just for Catnick. Yes, my lord.
Okay.
Thank you.
Thank you. Yep.
And so the observations I'd make on this, firstly, as Lord Hoffman himself acknowledged in Amgen, it's quite strange to ask about the primary literal or acontextual meaning of a word. That's the way he sets up the questions, because no word can be construed acontextually.
Yes.
And that's not what the continental approach is, where they would construe it in context first of all, and then ask about equivalence. And then in question 3, as characterised by Lord Hoffman, he introduces, in the second line of question 3, from the language of the claim. Those are not words that were used by Lord Diplock in Catnick, and he talks about the primary meaning. And again, in Catnick, Lord Diplock referred to a descriptive word, phrase. So we say that Lord Hoffmann has emphasised meaning at the expense of meaning of words at the expense of equivalence generally, and then that again is emphasised by the final paragraph and his question about the literal and figurative meaning, etc. What he doesn't do in this passage is give any room for an embodiment, an inessential variant which the patentee had not thought of at all. And there's no room, we would respectfully submit in this passage, for things that the patentee has left out, either through imperfect drafting or by the fact that he or she was not prescient of every possible development.
But it
and
can't
that is
surely what the particular patentee thought of or didn't think of, because on any view we're dealing with objective construction.
Yes, I'm
the
sorry.
question is whether it would have been obvious to the skilled outsider.
Yes, I accept that, my lord. I'm sorry. I've tried to take a shortcut and I was wrong.
But doesn't that rather reduce the force of your point once you accept it's put that way?
It may do. It depends whether, if you, as we submit, understand that the patentee is aware of equivalence, aware of Article 2, as Virgin says that the skilled person should be aware of drafting techniques, then that's fine, because the skilled person would be aware that the patent is meant to take account of equivalence. And indeed, we say this encourages a concise and clear approach to claim drafting, with the provision that equivalents are then covered, rather than trying to write woolly drafting, expansive wording into your claim to cover things that you're not sure whether you need to or not.
Well, all of this problem arises because of the classic way in which English law works, which is that you have a box with a label in it on it, and the label doesn't really cover what you're trying to fit into the box. Instead of opening a different box, you say, well, of course, it's really not much the same sort of thing, really, even if it's different. And we are actually being, arguably at least, led astray by the labels which have been put on the box before the problem actually was properly considered.
My lord, yes, but we would say that in addition to the normal construction of contracts, etc., there is this additional provision in patent law which requires the court to take account of equivalence, but for the reasons that we've already given, which may make a difference to the approach to the in general.
Okay.
My lords, there's further reference to the language towards the bottom.
Notable his reference at the bottom of the page, and over the next page to Lord Justice Fox talks about language again.
Yes, indeed.
Yep.
So that was on the main question. Then he gets to, so those are the bits where we say that too much emphasis on these passages leads one to go wrong. In contrast, we say on question 2, Lord Hoffmann's approach was right in Improver, and if the courts below had adopted it here, they would have said that question 2 should be answered in Lilly's favour. So let me show you that, if I may.
What, question 2 on page 189?
Question, yes.
Yes, except that, I know, without looking at how significant it is in the present case, it's quite important that question 2 is limited by reference to the date of publication of the patent, because that's a view you have to take if you regard it as a pure question of construction.
Yes, I think that the problem that arises, my lord, is, and this is where Lord Justice Floyd went in the Court of Appeal. He said, oh, you can't import things into issues of construction from after the date of the patent, because that could change. And we accept that, but we're not saying, because we say this isn't an issue of construction.
Exactly.
And so it is legitimate to take into account the characteristics of the infringement, because you are not changing the meaning of the words in the claim. You're merely asking whether this thing that's turned up 10 years later is an equivalent or not. And so, my Lord, we say that that's how we deal with that. And Lord Justice Floyd was wrongly concerned with the issue of construction when addressing this.
Well, he hadn't got any choice, given the authority binding on him.
Indeed. So, on infringement, my Lord, and in this case, And Lord Hoffman returns to this in Amgen, and I'll come back to that later. But perhaps your Lordships would just read on page 192, the first two paragraphs under the heading, under question 2, and then I've got some comments to make on that, if I may.
What, the first two paragraphs?
Yes, please.
Yep. So this picks up your point that in order to test this, you've got to know the infringement.
Of course.
Alleged infringement.
Yes, my Lord, it does. And we say a number of points. Firstly, the important thing is whether the variant works in the same way as the invention, not whether it works, full stop. And secondly, Lord Hoffman makes it clear in this case that you can cover inventive variants, even things that are improbable. And of course, if they're improbable, we say that the skilled person will be likely to have to do a test on it to work out whether it works in the same way. So we say that this passage does envisage that simple testing is permissible. And then Lord Hoffman goes on page 193, the top of 193, to distinguish between those things that matter and those things which don't matter for his purposes for question 2. And he says, the first full sentence on 193, the experts, also agree that it would have been obvious that any rod which had these qualities in sufficient degree and did not have other defects, such as overheating or falling to bits, would in principle work in the same way, and that the rubber rod plainly belonged to that class. So, my Lord, we say it's clear here that Lord Hoffman is excluding irrelevant aspects of the invention from the test under question 2, and we would say that would include solubility in the present case, because that's not part of the invention. So he's assuming that the variant does not have defects and it works sufficiently well, and then you have to ask, does it work in the same way as the invention? And well, also we say that supports our primary submission that solubility is just irrelevant to the question of whether the claim has been infringed in this case. Lord Hoffman then goes on to address question 3, and I'm not going to go into this in great detail, but what he does with reference to question 3 is he relies on the evidence of the experts in that case that although the rubber rod would work in the same way, it would not work for the vast majority of the embodiments in that case. And this is on page 195, just above the second hole punch, where he quotes a piece from the experts where it said that the figures 9 to 14, which show the possible configurations which the patentee had in mind, except possibly for the first, figure 9, these configurations could not be adopted by an elastomeric rod. And he then goes on in his findings on question 3. This is one of the reasons he gives for finding that question 3 was to be answered against the patentee in this case. And this is on page 197 of the report, the paragraph in the middle of the page. Perhaps your Lordships would just look at that.
Page 197.
197, yes.
Thus interpreted.
Yes, please.
Yes.
So on the facts of that case, there were very limited circumstances in which the variant and the invention would work in the same way, and there were problems which might be very difficult to overcome. and so he held that didn't satisfy the claim.
Okay.
He then goes on to refer to the German decision. He didn't have the benefit of the Dutch decision, which also found infringement, and it may be that he would have been, although he was clearly troubled that he was not following Germany, he may have been even more troubled had he known about the
Are you
Dutch.
vulnerable to a similar comment to the one Lord Hoffman made? Hoffman made as regards your having done no work on alternatives to bisodium, and it wouldn't be obvious. There might be problems with some of them when it came to solubility and that sort of thing.
Well, there might be problems with some of them, my lord, but they are easily solved because you would have an expectation that there would be alternatives and you could easily find what they were. So I'm not suggesting that every single salt could easily be made into a medicament, because there are some, the evidence is that there are some that are not as soluble, and that would be a problem. But it would be routine to find out which those ones were and exclude them. So that's the difference on the facts between Improver and our case.
They would have needed to make some more inventive steps or take some more in order to embrace rubber rods.
Indeed, Lord Hoffman says it would be very difficult to overcome the problems, and that's not the factual scenario in our case that the judges found to the contrary. So, my lord, that's Improver, and I've already referred to Marks and Spencer.
Sorry, can I just follow up that last point that you made? Clearly, if this is a process of construction, it's not just difficult, but impossible to regard a helical spring as equivalent to a rubber rod. But suppose it's a separate process, a second stage after you've done the construction. Is it your submission that on the facts of this case, the result should have been different in that event?
On the facts as we see it in this judgment, I don't think I can say that, and I don't need to say that, because...
But now, why is that? If you're looking at equivalent, according to your test, why wouldn't the rubber rod have been good enough?
Well, it depends on Lord Hoffman's analysis of the specification of the patent,
Yes.
and the importance of the helical spring in the specification. The helical spring was a core part of the invention in that case, and the specification kept referring to it, and the embodiments required a helical spring, as Lord Hoffman has observed. So if you look at it that way, then he is effectively saying it's not an inessential variant. It matters to the skilled person.
You still have to look at what is the inventive step.
Yes.
Even if you're not hidebound by the language when you come to stage 2.
And in this case, the inventive step was the use of the helical spring.
It's in some ways quite difficult to translate the approach in relation to what you say is a non-essential element of a molecule or chemical compound to a feature of a mechanical invention, isn't it?
It is, and it's easier, perhaps, conceptually to do it for mechanical equivalents. But, I mean, my lord, we have to accept that it was seen, this result was seen as a divergence from the approach that should be taken under the EPC. And that's why Article 2 was brought in. So to the extent that other countries seem to regard this decision as being wrong,
Yes, I mean, other
then we adopt that.
That it was equivalent.
I'm sorry, my lord.
As I understand it, other countries reached the conclusion that the rubber rod was equivalent.
Yes,
Yes.
that's right.
Germany and the Netherlands.
Yeah, in particular. I think it got to the higher courts in those. I'll find out again over lunch. We don't have those decisions, I'm afraid, in the bundles. But
That was because they applied a two-stage process.
My lord, yes. Because that's the only difference, because effectively Lord Hoffman had found for the patentee on question 2. So
It may be that it would have been the same result, because even where the facts are the same, sometimes the expert evidence that's accepted is differed, and sometimes it's a question of degree, and different
Of course,
judges
and
can reach different...
And I don't say every case has to be identical
No.
in every jurisdiction.
No, what I mean is that the slight difference in approach may not have been responsible for the different answers, but it could have been.
Indeed.
Yeah. Okay, thank you. Where do we go to
now
next?
To Amgen, please.
Right.
At 5 to 1. But we'll make a start if we may.
Yep.
And that's at tab 7. And this was the erythropoietin case where my Lord Neuberger found infringement of Claim 26 at first instance, but was reversed by the Court of Appeal, and the House of Lords upheld the Court of Appeal. And my Lords, we do suggest that the judgment repays reading in full all the way to paragraph 85, because there's lots in there. We would submit there's lots in there both for us and for Actavis. But our overall submission is that the interpretation...
You're now talking about the decision of the House of Lords.
I am,
Yeah.
Lord, yes, at tab 7.
Just check.
My Lord Neuberger's judgment was very full, and we haven't got that in the bundles, but we can get it electronically.
No bundle exists that's big enough for it. Yeah.
Well, I wasn't necessarily suggesting we should read 85 paragraphs of my Lord, but we could.
I wouldn't advise it.
And so, my Lord, the three overall submissions we have on this, that it requires a focus on the precision of language, which departs from the policy and the requirements of the protocol. It fails to take into account that the patentee might not have contemplated all of the obvious equivalents, and it, as we've already discussed, it focuses on a single step of construction and equivalence, which we say leads one into error. So if we can pick it up, please, at paragraph 9 on page 2516 in the physical bundle.
Yes.
And at the end of paragraph 9, Lord Hoffman explains what the invention in the patent is, and that is the introduction of an exogenous DNA sequence coding for EPO into a host cell in which it would be expressed. And then at the beginning of paragraph 10, he explains what the infringement is, and that is in TKT's gene activation method, the EPO is expressed in a human cell by an endogenous gene naturally present or by cells derived by replication from such a cell. So the difference between the claimed invention was it was all in exogenous host cells, and the alleged infringement was taking place in a human cell. And he notes at the top of the following page in paragraph 10 that the TKT method could not have been done at the time of the patent. So this was a case about a future invention that was not possible at the time of the patent. And then if we may go on to paragraph 34, which is a paragraph particularly relied on by the Court of Appeal in this case, where he starts his discussion of purposive construction. And perhaps your Lordships would just read paragraphs 34 and 35, and then I'll make some observations and be time for the short adjournment.
Yes.
So the observations I'd make, my Lords, is that if Lord Hoffman was merely talking about the first step in the process, which is working out what the words mean, we have no problem with his observations here about the meaning of words. But if he is talking about the process as a whole, as the courts below have applied and understood it, it's far too narrow, because you are left stuck with the words you've chosen, and there is no room for equivalence, we respectfully submit. And the patent attorney is assumed to be all-knowing, and Lord Hoffman, as approach, requires the patent attorney to have expressly covered equivalence. And if
There's all-knowing people, not people inter rusticos.
Indeed, as he comments later. But there has to be, as far as he's concerned, a rational basis for departing from the strict language of the claim. That's the end of paragraph 35. We say that doesn't comply with Article 2, and you are left stuck with the language that's been used. And if this approach is adopted, equivalents are effectively written out altogether. So, my Lord, perhaps I can pick this up after the short adjournment.
Because he then turns to equivalence and rejects them.
He does. The general doctrine, and again we say that's been misunderstood because Article 2 clearly requires equivalence to be taken into account.
Very well. 2 o'clock then. Thank you very much indeed. Court's now adjourned.